Thank you very much for these kind words, for the kind introduction. It is a great pleasure and honor for me to be here with you today and address the issue of the rule of law in the Islamic legal system. I'm very grateful to the organizers for having invited me to start the first panel of today on democracy and the rule of law in the Islamic world with my presentation. I will address the rule of law as a possible focus of the work of the ILA Committee on Islamic Law and International Law, which has already addressed it in its last report. I have it with me here, the impressive report. I will show it. Impressive report, very much written by Professor Rehman. Here we have the first, a very comprehensive, interesting report already on the work of the ILA Committee on Islamic Law and International Law. And so I would like to highlight the rule of law as a possible focus of our work in the future. I will first try to identify some essential elements which can be considered as essential for an understanding what the term rule of law actually means. These elements can serve as a point of reference or matrix in our context when we talk about the rule of law and Islamic law. Secondly, I'll try to point out where I find the main difficulties of these elements in Islamic law. Thirdly, I'll try to highlight some examples where problems exist in practice and which I suggest should be in the focus of the ILA Committee on Islamic Law and International Law in the future. Now, what are the essential elements of the rule of law? What can we understand by the term rule of law? Let me quote the final report of the Austrian initiative to examine the role of the Security Council in strengthening a rules-based international system between 2004 and 2008. It pointed out that at the United Nations World Summit in September 2005, member states unanimously recognized the need for universal adherence to and implementation of the rule of law, both at the national and international levels, and reaffirmed their commitment to an international order based on the rule of law and international law. However, there are already earlier documents, such as the 1970 Declaration on Friendly Relations, which referred to the promotion of the rule of law among nations, and the Millennium Declaration of 2000, in which member states agreed to strengthen respect for the rule of law in international as in national affairs. Such a high degree of consensus on the virtues of the rule of law is possible in part because of the relative vagueness of its meaning. There are at least two approaches. Some see in it primarily formal aspects of a legal system, such as institutions and procedures. Others emphasize that it aims at substantive goals, such as the protection of rights and ultimately the fulfillment of justice. There are also significant differences between the rule of law as it is understood in common law and civil law systems, as well as in other legal traditions. The historical origin of the rule of law lies in efforts to regularize and limit the powers of a sovereign. The rule of law is thus distinct from the rule of man, implying power exercised at the discretion of one absolute ruler. Already the classical philosophers have stressed that if political activity were left up to decisions by individuals on a case-by-case basis, there would be a danger that their choices would be influenced by factors such as friendship, animosity, and self-interest, rather than justice. Plato and Aristotle pointed out that the law is the embodiment of reason and is therefore superior to the rule of man. Furthermore, the rule of law was distinguished from rule by law, whereby a ruler exercised power in a non-arbitrary fashion, but was not him or herself bound by law in any meaningful sense. This positivist conception of law has been advocated, for example, by Thomas Hobbes, who regarded the misery of anarchy, which he had seen in England's civil war, as the greatest evil that can ever happen in this life, and concluded therefrom the need for an absolute and uncontested sovereign power to rule. However, commentators have rightly pointed out that despotism, even when pursued by a ruler full of the spirit of improvement, is still despotism and susceptible to all the vices of tyranny. So the great question is, as John Adams put it in 1787, the Age of Enlightenment, what combination of powers in society or what forms of government will compel the formation of a good and equal law, an impartial, good and equal laws, an impartial execution and faithful interpretation of them, so that the citizens may constantly enjoy the benefit of them and be sure of their continuance. Now, in our days, the UN in 2006 created a specific rule of law unit, which aims at promoting the rule of law at the national and international levels. The UN regards respect for the rule of law as fundamental to achieving a durable peace in the aftermath of conflict, to the effective protection of human rights, and to sustained economic progress and development. According to the UN, the term rule of law has to be understood in this way. It is a definition taken from the website of this rule of law unit. It is taken from the report of Secretary General Kofi Annan in 2004 on the rule of law and transitional justice in conflict and post-conflict societies. So it's an entire report dealing with the issue. And here is a rather long, comprehensive definition, but let me nevertheless quickly go through it and then subtract a summary out of it as the key elements. So the text and on the homepage, what is rule of law according to the UN, is a principle of governance in which all persons, institutions and entities, public and private, including the state itself, are accountable to laws that are publicly promulgated, equally enforced and independently adjudicated, and which are consistent with international human rights norms and standards. It requires as well measures to ensure adherence to the principles of supremacy of law, equality before the law, accountability to the law, fairness in the application of the law, separation of powers, participation in decision-making, legal certainty, avoidance of arbitrariness, and procedural and legal transparency. From these three basic elements of the rule of law can be identified, as was also pointed out in the Austrian final report. First, the powers of the sovereign may not be exercised arbitrarily. This incorporates the rejection of the rule of man and requires that laws be prospective, accessible, and clear. Secondly, the law must apply also to the sovereign and instruments of the state, with an independent institution such as a judiciary to apply the law to specific cases. This implies a distinction from the rule by law. Thirdly, the law must apply to all subjects equally, offering equal protection without discrimination. The law should be of general application on consistent implementation. These elements of the core definition may be summarized again as 1, a government of laws, 2, the supremacy of the law, and 3, equality before the law. Now, what about the rule of law in the Islamic legal system? The ILA Committee's report, already mentioned before, of 2010, has already started to address this issue. It points out that the rule of law is a system where the law is supreme and protects people against the arbitrary power of individuals and the state. is an important feature of Western legal tradition and political philosophy. The report raises the question whether the rule of law can be established outside Western liberal democratic systems and capitalist ideologies. It admits that there are some characteristics of the Islamic legal system which seem to be irreconcilable with the concept of the rule of law. These include the sacredness of the law, the sources of Islamic law, and the position of certain individuals. In addition, the report points out that the rule of law emphasizes the preservation of individual liberty and imposes duties on the state. In contrast, in an Islamic state, the emphasis frequently is on duties being imposed on its citizens rather than on the state. However, the report also highlights that certain characteristics of the Islamic legal system may provide reasonable theoretical basis for a limited rule of law system in a Muslim state. In the history of Islam, both Sunni and Shia scholars have offered different theories of state and law. A number of Sunni jurists have articulated ideas and principles which limit the role of the caliph and the Islamic state. The report points out that the original sources of Islamic law, the Quran and the Sunnah, contain the concept of public policy and expediency. In addition, secondary sources of law such as masala mursala, consideration of public interest, urf, custom, and ijtihad, personal reasoning of learned Muslim scholars, could also be a basis for legislation in an Islamic legal system. Now I'd like to turn to the two selected problems of the rule of law in practice. The rule of law is important in various areas of law. The discussion in the ILA committee should therefore not remain general and abstract. I think that a differentiated approach is needed and that the various areas of law with their respective specific problems should be identified. The ILA committee's 2010 report concentrates on the rule of law in humanitarian law, but also other areas of law deserve closer examination, such as constitutional law, criminal law, family law, and economic law. As regards humanitarian law, the committee's report shows that numerous elements of the rule of law can be found in the legal sources of Islamic law. It notes, amongst others, the various limitations to the right to warfare and the ontological imperative of mercy. And it points to the prophetic practice of tolerance and successive caliphs and companions of the Prophet. In addition, I would like to draw your attention to the importance of constitutional law for the implementation of the rule of law at the national level. Several studies have already analyzed constitutional law in Muslim states. For example, I find very remarkable Nasrin Abiad's study published at the British Institute of International and Comparative Law, but more recently Oxford University Press has published a book like this on comparative constitutional law in Islamic states. So there is already some study being done. And they have tried, amongst others, to identify the role of Islamic law within the law of the state. This could also represent the starting point of the committee's work, namely to examine the status of Islamic law in a variety of Muslim states. The committee can try to identify categories of different types of relationship between Islam and the state, including forms of strict separation of Islam and state law and strict identity of Islamic law and state law, as well as various intermediate types in between. This will show the diversity of Muslim states and the need for differentiation. The analysis of the rule of law in the different types of constitutional systems should not be limited to the examination of constitution itself, but also should include organization and work of the judicial and administrative system. Furthermore, criminal law. The rule of law is particularly important in criminal law. Classical Islamic law contains hard punishments for certain offenses. The so-called crimes of hudud Offenses attracting prescribed hard punishments include theft, requiring the amputation of a hand, rebellion or armed robbery, requiring death, crucifixion, cross amputation of the hand and foot or banishment, adultery, false accusation and apostasy, punishable by death even. It is true that these hard punishments are frequently not applied in Muslim states. However, under the rule of law premise, it is necessary to know on beforehand, and as a general rule, what kind of punishment will follow a specific kind of crime. Non-application of such punishments in selected cases is not sufficient under the rule of law premise. The committee could analyze in which way Muslim states deal with crimes of hudud in practice. Then the discretionary crimes, the ta'zir, these are acts over which the heads of states are granted discretionary power to regulate. Here the committee could analyze also to what extent the states have implemented the penal laws which are in conformity with the rule of law premise. It has to be noted that the advent of Islam marked an improvement to the existing pre-Islamic systems. The Islamic criminal system introduced a qadi to resolve issues which were previously a tribal chief would have presided over disputes. Procedurally rules to prove or disprove charges were introduced. The accused was held to be innocent until he was formally convicted. Torture and coercion became unacceptable means of ascertaining the truth, and the principle of equality was implemented through various parts of penal law. All these improvements represented an important progress towards the rule of law. The committee could analyze to what extent the spirit of these improvements and progresses is reflected and implemented in the current criminal law system in Muslim states. Two more brief subjects, family law. The rule of law is also essential in private and family relations to the extent that they are regulated by law. The committee's 2010 report contains an instructive part on talaq, unilateral divorce given by the husband, and polygamous marriages. Both issues of family law pose a problem under the rule of law premise. Talaq can be pronounced even in the absence of the wife and without the involvement of the wife in the process. Under the rule of law premise, the important legal consequences of a divorce must be based on a more solid basis. Regarding polygamous marriages, the report mentions that under the Muslim Family Law Ordinance 1961 in Pakistan, a Muslim man is required to gain permission from an arbitration council before he can enter a second or further marriage, and that the marriage has to be registered. However, in practice, these obligations are rarely complied with. Yet the second or further marriages are still considered to be valid without authorization of the arbitration council and without registration. These kind of examples could be examined under the rule of law premise. Finally, economic law. Here the rule of law is also is highly important for economic growth, for investment and trade. It could be a rewarding task for the committee to elaborate the necessary aspects of a rule of law system which allows for an adequate legal protection of economic activities. The committee could start by an analysis of the scope and extent of legal certainty necessary for conducting economic activities. On this basis, the practice of a variety of Muslim states can be introduced and analyzed. This could include the national legal system, laws and regulations, national judicial institutions, the state's international obligations like WTO membership, investment treaties, as well as the record of disputes and the respect or non-respect of international awards and decisions. Let me now come to my conclusions. In my presentation, I intended to highlight possible future issues to be discussed in the framework of the ILA Committee on Islamic Law and International Law. I would also like to point out that the choice of methods is important and difficult. A comparative analysis of the legal sources could be a starting point. However, texts alone would not be sufficient for gaining an adequate picture of the existing realities. Courts' judgments and tribunal awards should be analyzed as well, and in addition, historical, political, and social and economic, I would add, due to the focus of our meeting here, studies should be included in order to gain an adequate picture of the actual legal situation in Muslim countries. It appears, therefore, that an interdisciplinary approach should be considered in the future work of the ILA Committee on Islamic Law and International Law. I thank you very much for your attention.